Thank you very much. It is a pleasure to be here. As Igor has already suggested, my lecture will not be the cutting edge of maritime law. I'm sure Lucy will get to that when she starts talking about autonomous vessels in an hour or so. This is very much a setting the table, much more focus on where we have been, how we got to where we are, what the current state of the law is, and what that history involves. As Igor has already mentioned, we've been celebrating the centenary of the Hague Rules. Indeed, it's in the very title of this conference. But the story doesn't really begin in 1924. The Hague Rules allocate the risk for cargo carried under ocean bills of lading. It is therefore helpful to begin with the pre-existing risk allocation. Now, under early 19th century maritime law principles, which most maritime nations respected, the carrier was liable for cargo damage unless it could prove, first, that its negligence had not contributed to the loss, and second, that one of four accepted causes, act of God, act of public enemies, shipper's fault, inherent vice, was responsible for the goods. If an exception applied, the carrier was liable only for its own fault. In all other cases, it was liable without fault. That extensive no-fault liability led many to describe the carrier as an insurer of the goods. Although that label is incorrect as a strict technical matter, it well conveys the idea that the carrier assumed a very broad liability for cargo damage under general maritime law. Now, the major maritime nations accepted this risk allocation as a matter of principle, but they differed in its application. The British courts, for example, viewed that risk allocation as a default rule, applying in the absence of an agreement to the contrary. In deference to freedom of contract, the shipper and carrier could agree on a different risk allocation, including one in which the carrier assumed virtually no liability, even for its own negligence. Most European and Commonwealth countries eventually followed the British lead. In the United States, on the other hand, freedom of contract was somewhat more restricted. Carriers could limit their liability in most circumstances, but they could not exonerate themselves from the consequences of their own negligence or their failure to provide a seaworthy ship. The Japanese commercial code was very similar. Now, that conflict meant that general maritime law no longer provided a completely uniform risk allocation. The desire to restore some of that uniformity ultimately produced the Hague Rules, but it was an extended process. In 1882, the International Law Association promulgated a model bill of lading, which became known as the Conference Forum. That Conference Forum never achieved general acceptance, but it was a first step and it was influential in the later developments. In 1885, the ILA proposed what we might think of as the first set of handbook rules for voluntary incorporation by reference into bills of lading. The rules proved unworkable. In 1887, they were rescinded. And after 1887, the ILA turned to other subjects. With this breakdown of international efforts, cargo liability interests became increasingly frustrated by what they perceived as carriers overreaching. The United States took the lead in addressing this. In 1893, the Harder Act was adopted as a compromise under which a carrier's obligation to furnish a seaworthy vessel was reduced, becoming simply an obligation to exercise due diligence. And if the carrier exercised that due diligence, it would not be liable for damage or loss resulting from faults or error in navigation or in the management of the vessel. Other countries with strong cargo interests soon followed the US lead. New Zealand in 1903, Australia in 1904, Canada in 1910. That domestic legislation made the conflict among national laws more serious in the short run, but when carriers were subject to conflicting regulation, they had more incentive to support an international solution. So with this background in mind, we can now turn to the 1920s. The immediate impetus for the Hague Rules came from the British Empire. While ship owners were politically powerful in Great Britain itself, the situation was reversed in the overseas dominions. As the First World War was coming to an end, the dominions pressured the imperial government to coordinate harder-style legislation for the entire British Empire. In 1917, the Dominions Royal Commission recommended such legislation. In 1918, the Imperial War Conference concluded that the issue required investigation. In February 1921, the Imperial Shipping Committee concluded that there should be uniform legislation throughout the empire on the lines of the existing acts dealing with shipowners' liability. And in the summer of 1921, an Imperial Conference committed all of the governments involved, including the British government, to introducing such legislation in their own countries. Now, British opposition had long been a principal impediment to international rules. But when the British government was committed to domestic legislation on the topic, the prospect of an international agreement was much more appealing to the British shipowning interests. If they were to be subject to regulation in their home ports, they preferred uniform regulation wherever they did business, and just as significantly, comparable regulation for their foreign competitors. The British therefore took the lead in resurrecting the work of the International Law Association. In May 1921, the ILA's Maritime Law Committee met in London. Despite indignant protests from British shipowners that freedom of contract was the appropriate regime, the committee agreed to draft uniform model rules for ocean bills of lading based on the Canadian harder style legislation. A month later, the draft was complete. The ILA held its next conference at The Hague in September 1921. The Maritime Law Committee met in separate session to discuss the draft. After 4 days of debate between cargo interests, including bankers and underwriters, and carrier interests, the members unanimously agreed on the text of the Hague Rules, and their agreement was ratified by the full association plenary session. Like the York-Antwerp Rules, the 1921 Hague Rules were intended for voluntary incorporation by reference into bills of lading. Shipowners temporarily preserved their freedom of contract while conceding their willingness to assume greater liability for cargo if the shippers demanded it. Shipowners were cautiously pleased with the results of the Hague Conference. Although they continued to argue for freedom of contract, they preferred the 1921 Hague Rules to different legislation in every country. The World Shipping Conference in late 1921 thus recommended the rules for voluntary international application. But recognizing the strength of cargo interests, they conceded that the rules were suitable for adoption by international convention, quote, if and so far as may be necessary. Reaction among cargo interests was mixed. Their principal objection was the voluntary nature of the rules. British shippers in particular demanded the legislation that they had been promised in the Imperial Conference. When the British Board of Trade announced that the government was prepared to introduce a bill in Parliament similar to the Canadian Act, the shipowners made the best what they viewed as a bad situation. The Board of Trade arranged a meeting between Sir Norman Hill, the leading carrier spokesman, and Andrew Marvell Jackson, the legal advisor of the British Federation of Traders Associations. They proposed compromise legislation based on the Hague Rules of 1921 to replace the government bill. The CMI then started to play the central role. At the London Conference in October 1922, the Hill-Jackson Compromise draft was the basis for further discussion. The delegates reviewed the entire code section by section, adopting most of the Hill-Jackson changes and adding some new amendments that others had favored. To meet the demand for an international convention, CMI also put the rules into a legislative form. By the end of the London Conference, a draft was ready for diplomatic consideration. The CMI's London Conference ended on October 11th, 1922. 6 days later, the fifth session of the Diplomatic Conference on Maritime Law opened in Brussels. The last-minute addition of the Hague Rules to the agenda did not interfere with the conference's ability to discuss them. Delegates representing their countries in Brussels had met as individuals at the CMI conference in London the week before. But the last minute change did mean that most delegates had not received instructions from their governments and thus were unable to commit their countries to the final text. The diplomatic conference appointed a Sioux commission to review the CMI draft, recognizing that it was a compromise among the interests involved. The Sioux commission proposed almost no changes in substance. Plenary session subjected the draft rules to a section-by-section review. By this point, the pressure not to change the text was so strong that the only substantial amendment was to resolve an open controversy regarding Article 3.6's notice of claim and time for suit provisions. Because most delegates lacked the authority to commit their governments, the conference agreed that it would adopt the text simply as the basis of the convention. Then, in October 1923, an expanded Sioux Commission reconvened in Brussels to examine the comments that the 1922 draft had generated and to consider final changes. Most of the 1923 discussion simply clarified the intent of the text. The one significant revision was the addition of the gold clause in Article 9 of the Convention. After the 1923 meeting, all that remained to be done was of a ministerial or formal nature. The Sioux Commission's changes were incorporated into the rules. Technical provisions governing such topics as ratification, denunciation, and amendment were added. Finally, in August 1924, the conference formally reconvened for the official act of concluding the convention and opening it for signature. And that's the centenary that we've been celebrating for the last year. Of course, the formal signing of the convention is not the end of the story, but the beginning of a new chapter. For the Hague Rules to have real meaning, they needed to be ratified. And the ratification story, by its very nature, proceeds in separate strands in many capital cities around the world. I will discuss two very different ratification stories here. The British government, having pledged to enact the legislation based on the Canadian Act, moved very quickly. Indeed, the government did not wait for the diplomatic conference to complete its work, but introduced a bill in March 1923 to enact the then current draft of the Hague Rules as domestic law. Although there was widespread support for the bill, there was also some vocal opposition. Most of the commercial opposition was either irrelevant or ill-informed, but Lord Justice Scruton, a judge of the Court of Appeal, the author of the leading treatise on charter parties and bills of lading, and the most respected commercial jurist of the generation, argued that the rules were unclear and would most likely lead to increased litigation. The parliamentary session expired with no action being taken. The British government introduced a new carriage of goods by sea bill in February 1924 to enact what was then the latest version of the Hague Rules, as amended by the Sioux Commission the previous October. That bill passed Parliament with little discussion, and the British Carriage of Goods by Sea Act received the royal assent on August 1st, 1924, 3 weeks before the diplomatic conference completed its formalities. Other countries in the British Empire soon followed the mother country's lead. Australia enacted its new Sea Carriage of Goods Act later that year. India enacted its COGS in 1925, and so on. Outside the British Empire, however, the response to the Hague Rules was, shall we say, less enthusiastic. For the United States acted in 1936, only Belgium had passed national legislation implementing the Hague Rules, as the International Convention was still called, despite the significant changes since the Hague Conference. In the United States, we had a very different story than in Britain. There was vigorous commercial opposition from a small group of cargo interests, but apathy, inertia, and simple misunderstanding were even more powerful roadblocks on the route to ratification. The organized opposition came primarily from a few shippers who hoped that they could do better. No one seriously denied that the Hague Rules were an improvement over the Harder Act as far as cargo interests were concerned. But a few believed they could obtain a radical amendment of the Harder Act that would be even more beneficial. They were therefore unwilling to accept more modest improvements, for fear that they would make it impossible to obtain more sweeping changes. In February 1923, the first bill was introduced in the House of Representatives, a month before the first British bill was introduced in Parliament. As in Great Britain, it was too late in the legislative session for the bill to be enacted. As in Great Britain, affected cargo interests shared their views in legislative hearings. But the similarity with the British experience ended there. Between 1923 and 1930, 7 more bills were introduced in Congress to enact the Hague Rules. 3 more congressional hearings were held, but nothing came to a vote in either the House or the Senate. It was clear that Congress would not approve legislation, however desirable it might be, if there was serious opposition from any U.S. interest. The matter was too technical for politicians to make an independent judgment, and Congress would act only with the unanimous support of the interested parties. The major turning point came in November 1930, when the U.S. Chamber of Commerce sponsored a conference to consider the Hague Rules. That conference recommended 7 amendments to clarify the bill. When proponents accepted those amendments, opponents dropped their objections, supported the measure. It appeared that prompt passage would finally be possible, but new obstacles delayed enactment for another 5 years. The biggest obstacle was the Great Depression, which focused Congress's priorities on more urgent matters. A new bill was introduced in every congressional session, but no hearings were held. The Hague Rules sat on the back burner while Congress enacted the New Deal. The final push began with the introduction of another bill in 1935. When the Senate Commerce Committee held a hearing, only supporters appeared. Even previous opponents testified in favor. The bill passed the Senate without a recorded vote. While the bill was pending, the Senate also gave its advice and consent to the treaty with a single reservation, that the package limitation would be $500, which is then only a few dollars more than 100 pounds sterling. The Senate's action in passing the bill and approving the treaty put pressure on the House to pass the bill before Congress adjourned. For U.S. cargo interests were eager to ensure that the compromise reached at the Chamber of Commerce became a part of the domestic law before ratification. Thus, the hearings on the House side were filled with testimony in favor of the bill. The Committee on Merchant Marine and Fisheries reported it favorably, passed the House without discussion. A week later, President Roosevelt signed the bill, and the Carriage of Goods by Sea Act became law in 1936. Before then, other countries had hesitated to adopt the Hague Rules. Indeed, there had been a movement among British ship owners in the early 1930s to repeal the UK Codicil on the ground that the rest of the world was unwilling to accept international uniformity. Elsewhere, Italy tentatively approved the convention in 1928, but postponed its ratification until other nations committed themselves. France discussed withholding its acceptance of the treaty until Germany, Italy, and Norway ratified it. With US ratification, however, the world's remaining maritime powers joined the new regime fairly quickly. Canada passed its new Water Carriage of Goods Act barely 2 months after the US Codicil. Within 2 years, France, Italy, Germany, Poland, the 4 Nordic countries had all followed suit. By 1938, the overwhelming majority of the world's shipping was committed to the Hague Rules. But then we had the breakdown in uniformity again. Although the Hague Rules provided a widely accepted regime, the uniformity began to break down soon after its widespread acceptance. In part, this was due to the changing world political situation, as former colleagues became independent countries with their own agendas. National court interpretations of the Hague Rules produced problems calling for new solutions. Developments in the world economy produced a particularly visible problem, as shifting exchange rates left limitation values that varied by a ratio of over 3 to 1. The immediate impetus for the visit was a conflict over the scope of the convention. Under Article 10, the Hague Rules apply only when a bill of lading is issued in a contracting state. In the well-known Vita Food case, the Privy Council held that it was proper for a Nova Scotia court to apply English law under choice of law clause rather than applying the Hague rules. Notwithstanding that first the Bill of Lading had been issued in Newfoundland, then an independent dominion, not yet part of Canada, and Newfoundland was a party to the Hague rules, thus meeting the Article 10 criteria. Secondly, the shipment was from a Newfoundland port, and a Newfoundland statute provided that the Hague rules would apply to any shipment from a Newfoundland port. And third, the UK, the country whose law had been chosen in the Bill of Lading, was also a party to the Hague rule. But Nova Scotia, the forum state, was a province of Canada, which had not yet ratified the Hague rules at the time of shipment. So the Nova Scotia courts were not bound to follow Article 10 or the Newfoundland statute. And under English law, the Hague rules were mandatorily applicable only to shipments from UK ports. Vita Food thus highlighted the benefit of a broader scope of application provision. The revision process began with a report from the CMI's International Subcommittee on Conflicts of Law, which focused on revising Article 10 to provide that broader scope of application. The report concluded, however, with the suggestion that further changes, particularly in the limitation amounts, should also be considered. After extensive discussion during the plenary session of the Rijeka Conference in 1959, just up the coast from here, the CMI overwhelmingly voted to amend the Hague rules to govern inbound and outbound voyages when the goods were shipped to or from a contracting state. The conference also decided that a subcommittee should consider what other changes should be made to the Hague rules. Between 1959 and 1962, the subcommittee on Bill of Lading clauses circulated several reports and held 2 meetings. In 1962, it made 7 positive recommendations and explained why it did not recommend 17 other changes. The positive recommendations included replacing the 100-pound packing limitation in the Article 9 gold clause with the package limitation defined in terms of the Poincaré franc, a unit of account linked to the official price of gold. CMI addressed the subcommittee's report at its Stockholm conference in 1963. After an initial discussion in plenary session, the issue was committed to the subcommittee for further study. On the final day, the subcommittee reported its conclusions on each of the positive recommendations in the 62 report. It also reconsidered 4 other subjects. Most controversially, it discussed a proposal to overrule the House of Lords' 1961 decision in the Muncaster Castle, which held that the carrier's duty to exercise due diligence to provide a seaworthy vessel was non-delegable. That proposal would have amended Article 3.1, provided that a carrier is not liable for the negligence of an independent contractor if the carrier exercised due diligence in the selection and supervision of the independent contractor. In plenary session, the conference accepted the subcommittee proposals, agreed to the Muncaster Castle proposal, and reaffirmed the proposed amendment from the 1959 Rijeka Conference to extend the scope of application. Finally, a draft protocol was signed in the historic Swedish city of Visby, thus justifying the name Visby Amendments and permitting the amended convention to be known as the Hague-Visby Rules. When the CMI's draft was submitted to the 12th session of the Diplomatic Conference on Maritime Law in May 1967, the delegates reached agreement on most of the issues fairly quickly. With only a few exceptions, the CMI proposals were accepted. The Muncaster Castle proposal, however, was resoundingly defeated in committee, and 2 subjects were so controversial that the delegates agreed to put them over for a second phase 9 months later: limitation of liability and scope of application. When the conference reconvened in February 1968, its solution to the limitation problem was more elaborate than the CMI's original proposal. While the CMI had retained the basic structure of Article 4 or 5 of the Hague Rules, merely substituting 10,000 Poincaré francs for 100 pounds gold, the Diplomatic Conference worked out an elaborate compromise: a weight-based limitation operating in conjunction with the package limitation, a container clause to clarify the identification of packages when goods are shipped in containers, and a provision for the loss of the right to limit liability for intentional or reckless misconduct. On the scope of application question, the diplomatic conference cut back on the CMI's proposal, which would have applied the amended convention to inbound and outbound voyages. But the diplomatic conference extended the convention's application to cover cases in which a bill of lading was issued in a contracting state, as under the original Hague rules, the carriage was from a port, a contracting state, or the bill of lading had a choice of law clause providing for the application of the convention or the legislation of a country giving effect to the convention. Thus, we had the Hague-Bisbee rules. But they were modified fairly soon, because when the Bisbee amendments were negotiated, the world's economy still operated under the gold standard. Thus, it made sense to address unit limitation and exchange rate issues with a gold-based unit of account, such as the Poincaré franc. This is Monsieur Poincaré, by the way, on the slide here. Between the time that the Bisbee amendments were signed and the time they went into force, the International Maritime Fund abandoned the gold standard and redefined the special drawing right as a unit of account based on a weighted average value of several major currencies. Thus, in 1977, the CMI recognized the need to update international conventions that included limitation of liability based on gold values. An international subcommittee investigated the issue and prepared draft protocols converting Poincaré francs to SDRs, not only the Hague-Bisbee rules, but also the 1957 limitation convention. Thus, the Hague rules package limitation was converted from 10,000 Poincaré francs to 666.67 SDRs, and the weight-based limitation amount was converted from 30 Poincaré francs to 2 SDRs per kilo. In May 1979, the CMI submitted the draft protocols to the Belgian government. The Belgian government convened a diplomatic conference in December 79, and that conference adopted the CMI draft protocols without amendment. Now, except for the relatively technical amendments of the SDR protocol, the Hague-Bisbee rules have remained unchanged for over half a century. As Igor has already mentioned, new conventions designed to supersede the Hague-Bisbee rules have been adopted, but they have not achieved widespread support. Although the Hamburg rules have been enforced since 1993, they govern only a small share of international trade. And too few nations have ratified the Rotterdam rules for them to come into force. As a result, the Hague-Bisbee rules continue to be the dominant legal regime for the international carriage of goods by sea. So I conclude by taking a quick look at where things stand today. Although this has been mostly a backward-looking presentation, we'll have a little bit of discussion of where we are now. A century ago, before the Hague rules, a little over a century ago, before the Hague rules, the world faced a variety of different regimes. Although there was widespread agreement on basic principles, general maritime law, different nations interpreted them differently in important ways. And several nations had enacted their own domestic regimes. All of that is once again true today. 50 years ago, before the Hague-Bisbee rules entered into force, the world faced a situation in which uniformity had broken down for a variety of reasons. Some technological, some political, some legal, some economic. Once again, that is true today. The Hague-Bisbee rules remain the dominant legal regime, but they are seriously out of date. They are, after all, simply the Hague rules with a small handful of amendments designed to address very specific problems. We thus have minor 1968 amendments to a 1924 convention based on an 1893 domestic statute that was designed to address the problems of the early steam era. The drafters of the Bisbee Protocol did not imagine electronic commerce. They barely dealt with the container revolution, which was still in its infancy at the time. While multimodal contracts routinely govern shipments on a door-to-door basis today. The Hague-Bisbee rules still apply on a tackle-to-tackle basis. And of course, many countries, including the world's two largest economies, are not parties to the Hague-Bisbee rules. The Hamburg rules are newer, but they're noteworthy for what they failed to do. 2 decades after the container revolution and the accompanying growth of door-to-door multimodal transport, they expand the Hague and Hague-Bisbee tackle-to-tackle scope only to the limited extent of port-to-port coverage. Although ships in the 1970s carried dangerous cargoes that were not even contemplated when the Hague rules were negotiated, the Hamburg rules treatment of shippers' liability is substantially the same as the Hague treatment. And the closest that the Hamburg rules come to facilitating electronic commerce is the recognition that telegrams and telexes should be recognized as writings. Has anyone seen a telegram or a telex recently? One. The Rotterdam rules, product of over a dozen years of work by the CMI and Trail, could provide a solution to the current problem. They're a modern regime that could once again unify the rules governing the carriage of goods by sea. They're specifically designed, they focus on facilitating the development of electronic commerce. They recognize the commercial realities of containerization and door-to-door multimodal contracts in today's world, but only 5 nations have ratified them. Other nations have signaled their willingness to ratify, but many have indicated that they're waiting to see what the United States will do. And the United States has shown no visible progress. Now, a full explanation of why the United States has not yet ratified would take a separate session here. Maybe we can discuss that during the discussion period at the end of this session. For the moment, let me just say that there are a combination of causes. And remarkably enough, none of those causes have anything to do with the substance of the rules. And I think it's probably fair to say, without getting myself into too much trouble, that the current administration has not done anything to offer us any reason for optimism on this front. I think the bottom line is that the time has come for the rest of the world to stop waiting for US leadership. The world needs a modern regime governing the carriage of goods by sea, whether or not the United States takes the lead in getting there. If the Rotterdam rules do not enter into force, it will be at least another generation before another alternative is available. The history I've discussed today contains many lessons that remain relevant. One of those lessons is that obtaining international uniformity is a challenging task that can easily be derailed by any number of completely extraneous factors. Success requires those striving for international uniformity to seize the opportunities when they arise. With that, I will turn the floor back and look forward to the questions that come up during the discussion period. Thank you very much.